Good morning, folks. This is the Colorado Oil and Gas Conservation Commission. It is September 21st, and it is 8:30 in the morning or a little bit thereafter, and we are taking up docket number 2011-00261. We have one commissioner that is running just a couple of minutes late, and so we are going to just hold steady until Commissioner McGowan joins us, which should be within about 5 minutes. At that point in time, we'll take roll call, we'll bring our attorneys up to panelists, and then we will move forward. So if everybody can just sit tight for just a sec, we will get going just as soon as we can. Thank you. Okay, we are all here, and so we're going to do two things at once. We're going to call the roll, and we're also going to bring our attorneys to the panel at the same time. So let's do that. Ms. Amaro, if you could bring the attorneys to the panel, and Ms. Larson, if you could take the roll call.
Of course. Thank you, Mr. Chair. Commissioner Bogue, Commissioner Gonzalez.
Here.
Commissioner Hackett, Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Excellent. And it's the 5 that we need, so we're happy to have all of us here. Good morning, everybody. Let's give Ms. Amaro a little bit of time to bring our attorneys to the panel. And then we will touch base on any procedural issues before we move into our morning docket. Okay, I saw Ms. Rosenberg. I see Ms. Stafford, Mr. Satterley. Do we need Ms. Carlson, Mr. Jacobs?
Ms. Carlson will not need to be elevated to panelist for the next couple of witnesses. Thank you.
Okay. Okay, before we move into the hearing proper, Ms. Stafford, does staff have anything procedurally that you feel we need to discuss?
Thank you. Excuse me. Thank you, Chair Robbins. I don't believe staff has anything procedurally other than we wanted to bring to your attention that we filed the documents that you had requested last evening. So we hope that those are helpful for you all.
Great, thank you. And remind Mr. Mueller and Mr. Jacobs that those documents were filed, and pursuant to the testimony of Mr. Kaufman, would appreciate some looking into the staff concept of the compliance plan. I also note for the record that the Montoya affidavit was also filed by KPK last night. Anything further from your end, Mr. Jacobs or Mr. Mueller, procedurally before we get going?
We do have one concern, and it's with the homework assigned to staff on spills reported prior to the rule change. We would like a response, an opportunity to respond, and we're checking as quickly as we can on the percent with 906B violations and 912B6 violations. We question the accuracy of those numbers, of whether there were actually violations alleged or NOAVs issued. So we'd like the opportunity to respond to that before the record is closed. But other than that, I think unless you have something, Kirk?
No, I have nothing else.
Then that's our only procedural point, Mr. Chairman.
Okay. I do not have a problem if you desire to file a position response relevant to the staff present, what staff filed. Just get that in before we get closed. So with that, I believe that we were at cross-examination of your last witness, Mr. Considine. Is that accurate?
Dr. Considine, yes.
Dr. Considine, sorry about that. So let's bring Dr. Considine to the panel. And we've got Mr. Satterley, who did the direct, so that he would be ready for any redirect following cross-examination.
Thank you, Chair Robbins. I do see Tim C. Dr. Considine is in the participants room, but hasn't been elevated to panelist as of yet.
We're working on it. Okay, we were
Thank you.
actually going to the KPK witness room, but we'll go to Tim C instead.
Thank you, Chair Robbins.
And Ms. Amaro, if we could move to speaker view and drop the participant piece, then we can all have a better view of who's speaking. Kind of like that approach. Give us just a sec as we get everything lined up here. I know this feels like it's taking forever. This is a lot quicker than a normal courtroom, I promise. Okay, Ms. Stafford, I believe that you're up and we do have Dr. Considine in the panel. So if you would like to start with cross-examination, the floor is yours.
Thank you, Chair Robbins. I really only have a few things to discuss here. Dr. Considine, thank you for your testimony. We appreciate you being here with us. I'd like to direct your attention to a quote that is contained in your expert report. And please correct me if I misread this. Prior enforcement policies and decisions may be important to consider in determining whether the COGCC is now moving the goalposts for determining what is acceptable environmental risk. Did I read that right?
Yes, that's on the bottom of page 2, top of page 3.
Thank you. And Dr. Considine, are you aware of the Commission's mandate under Senate Bill 19181?
What I do know about that is the mandate stipulated preservation of the environment. It elevated the non-economic objectives of environmental protection, whereas which was a departure from the past mission.
Thank you. So now you would agree that the Commission's mission is to regulate with the focus of minimizing adverse impacts to public health, safety, welfare, the environment, and wildlife resources?
Yes, that is my understanding of the mission of the COGCC.
Thank you. I don't have anything further.
Mr. Satterley, any redirect?
No redirect for this witness.
Okay, I think it is now time for commissioners' questions. Dr. Considine, I had wondered yesterday if you had any thoughts, opinions, or knowledge about how other agencies, other states may deal with an ability to pay provision, language, et cetera. Do you have any thoughts along those lines?
When you posed that question last night, I reviewed my notes and did some internet searches. And what I discovered was the EPA has a set of models for quantifying penalties or the benefit of non-compliance. And these models look at the financials of the firm. So there's a well-developed set of tools out there available for states to use to assess penalties and estimate how those penalties would affect the ability to pay.
Okay, thank you. Other questions from commissioners? Commissioner McGowan?
Thank you, Mr. Chair, and thank you, Mr. Considine. Sorry, I'm not sure I had that right. But Dr.
Yes, Considine. That is
Thank you
correct.
for testifying today. How would you take into consideration other issues that might be going on with someone who's, when we're trying to figure out penalty to pay and ability to pay if they have, for example, a consent decree already with another department where that's been already taken into consideration?
I'm not quite sure if I understand your question. Could you rephrase?
So how does your math come into play or your decision-making matrix change if an operator already has outstanding other violations and an agreement that's been made with a different department or agency, and the ability to pay has already been taken into consideration for that penalty?
My reaction is you would look at you would do these calculations on a case-by-case basis, and the fact that I mean, you would have to separate the violations that you're considering and those that were considered by previous agencies. I think the bottom line, though, is how the penalty should reflect in some way the benefit from non-compliance. Okay, and that comes from delaying the costs of remediation and compliance over time. And whether the projects are linked or not, you mentioned the other non-compliance case is one of the critical questions that would have to be addressed. So I'm not quite sure, but the EPA documents have sort of two key parts in the calculation of penalties. One is the economic benefit from the non-compliant firm of delaying the cleanup, if you will. And then the second is the gravity of the event, of the pollution event. Is it serious? And a lot of times that second calculation is very difficult to make. Most of the time it's, you estimate the compliance costs essentially of cleanup. And if the firm has delayed that, then you take into account the time value of money. So there's a well-developed methodology here. How it links with previous projects, however, is a wrinkle that I imagine the staff could handle.
Thank you.
You're welcome.
Further questions from commissioners? Okay, seeing none, Mr. Satterley, any redirect following commissioner questions?
Redirect. Thank you, Chair Robbins.
Okay. I believe, Dr. Considine, that you are released from service. Thank you for being with us. Mr. Jacobs, do you desire to call your next witness?
Yes, we'll be calling Kevin P. Kaufman. If you'll give us just a couple of moments, I'm going to join him in the witness room on the same camera. So it'll be just a couple minutes till we're in there. Thank you.
Okay. Are we getting the witness room up?
The witness room is up.
Okay. Yeah, I'm not seeing it because
We had it. That's bizarre. No, they're, because I brought them in.
Great.
And Angelica started reading them.
they are an attendee.
Yeah. brought them in like. There they go. Why Zoom? Let's choose with them.
That's fine. Mr. Chairman, can you hear us okay?
Yes, we can hear
We
you.
can hear you. Very good.
Mr. Jacobs, could you do a mic check?
Yes. Can you hear me okay?
There's an echo in there.
Yeah, we're getting an echo. I wonder if you have more than one microphone on. Although maybe
It's just
try it one more time, Mr. Jacobs. Just mic check 1, 2, 3.
1, 2, 3 testing. 1, 2, 3.
Okay. It is now working without any reverberation, so I think you're good to go.
Okay. Thank you, Mr. Chairman. Sorry for any delay. With that, I have to be sworn in. Yes, you do.
AG Davenport, let's swear in Mr. Kevin P. Kaufman.
Good morning, Mr. Kaufman. Would you raise your hand and state your name and say that you swear to tell the truth, please?
My name is Kevin P. Kaufman, and I swear to tell the truth.
Thank you.
Mr. Kaufman, we have your name for the record. Thank you for being with us this morning. Would you please tell us what your current employment is?
I am the Chairman and Chief Executive Officer of KP Kaufman Company.
How long have you been operating KP Kaufman Company?
I founded the company in 1984, so for almost 38 years.
And what work experience do you have other than with KP Kaufman Company?
I was appointed and served as the United States Bankruptcy Trustee and Receiver for the state of Colorado from 1985 to 1992. I also served on several boards of directors for public, private, and industry entities, including on the board of Denver Health and Hospital Authority, to which I was appointed by then Mayor John Hickenlooper, and served as the chair of the Finance Committee for 10 years, from 2005 to 2015, among numerous other positions.
Thank you. So you've seen a number of market downturns over the past 38 years. Which of those downturns has been the most challenging for the company, in your opinion?
Well, obviously the most recent one beginning in 2014 and leading up to the secondary crash during the COVID-19 pandemic of 2020.
What did the company have to do to weather this latest downturn and the pandemic-related difficulties of the last 18 months?
Layoffs, restructuring to pay off all of our secured debt. We sold undeveloped Codell Niobrara rights, suspending our third-party drilling and interstate trucking companies and activities, and reducing our executive compensation drastically. And lest we not forget, the true and justified true fear in people. From March of 2020 Certainly through March of 2021, we had 42 of our 150 employees become ill and be quarantined under state and law and CDC guidance. Direct in-person meetings at every level became nearly impossible. Remote work management and communication platforms had to be established, and this had a major impact on our command and control.
Did those measures affect your ability to comply with COGCC's requirements applicable to your operations?
Well, as Rick Stoltz previously testified, we maintained our roustabout crews and EH&S staff at full levels through this difficult period. So while we were able to respond to spills and releases promptly and to report them if they were reportable, our ability to make progress across numerous other projects was slowed due to drastic reductions in free cash flow and availability of capital and at times personnel.
You heard prior KPK witness testimony about KPK's efforts to address historic contamination that is encountered at a number of NOAB locations and also some 901A order locations. How much has KPK spent to date addressing historic contamination not shown by staff to be the responsibility of KPK?
We spent over $4 million since 2018, of which $2.5 million was spent in 2018 through 2020, and $1,518,926 was spent in 2021 alone, addressing historical contamination with respect to the NOAVs and 901A order locations.
What is the primary constraint on KPK's ability to make better progress in the closure of NOAV sites and the remediation and closure of 901A order sites?
There's cash flow constraints on the company. Even with no secure debt, we are a cash flow business. And the oil prices are more stable and improving. We're required to operate within these limitations. We experienced negative EBITDA or cash flow from 2016 through the first quarter of 2021. The company sold remaining Codell Niobrara rights, and I personally loaned KPK funds, and the company privately negotiated agreements with developers and generated resulting P&A income to cover these negative cash flows.
What about the 901A order requiring you to shut in 87 wells served by 29 locations? Is that impacting your cash flow and thus your ability to fund more remediation work and speed your progress?
Yes, of course. Although we've made very substantial progress at those locations, the order has not been relaxed at all, and it has deprived us of nearly $300,000 a month in production revenue since April, or $1.5 million to date, that would have been available in large measure to fund additional work at an accelerated pace.
Mr. Kaufman, does KPK have a prohibition on use of third-party contractors to do remediation work and spill response?
No, we do not. Look, Kaufman Well Service is one of the largest well service companies in the DJ Basin, with nearly $40 million invested in service assets. We have great capability and capacity to do that work efficiently and effectively at lower costs due to our investments in equipment and the personnel in Kaufman Well Service. We do engage third-party contractors for specialized technical consulting work and for short-term requirements to increase capacity on specific projects. We remain open to the use of third-party contractors like Mr. Haddle with Apex Consulting for specific projects and others.
Now, turning to staff's requested relief and penalties. Staff is also seeking more than $1.6 million in penalties from KPK for the violations initially found by the Commission in the earlier phases of this hearing. Can KPK afford to pay such a penalty?
No, we cannot. Certainly not in the near term, and still meet our obligations. Imposing such a fine would have serious consequences not only for KPK and its 150 employees, but also for the mineral owners and state and local governments you've heard previously from Dr. Considine. And that does not account for the proper maintenance and then eventual disposition of KPK's 1,300 wells and many miles of flow lines that require attention and eventual reclamation and abandonment without the company's production revenue to support it.
And regarding staff's request for POV sanctions, Could you possibly complete remediation and closure at NOAB locations and 901A order locations if all of your certificates of clearance were suspended?
No. That would be a fatal blow to the company. Without production revenue, we can't continue our operations, much less complete remediation, and would likely seek bankruptcy protection at a minimum, among other measures.
Would KPK be open to a structured settlement in concept, one that would harness a portion of net cash flow from production revenue of the company to accelerate remediation and promote a return to compliance at the locations of concern to staff in this proceeding?
Yes. And in fact, we've made proposals to staff, but they've been unwilling to negotiate to date whatsoever.
If that were to come to pass, what does the future hold for KPK?
Well, first and foremost, KPK has over 4 million barrels and 25 BCF of crude producing reserves remaining, which is a net 3.2 million barrels and 20 BCF to KPK. This represents approximately $410 million of gross lease revenue, of which there's approximately 70 million in future royalty revenue, 23 million in state production and county ad valorem taxes, and 283 million in net revenue to KPK. This, combined with KWS service income in P&A projects from developers and other projects, is more than ample to meet our operational and remediation total P&A obligations over the next 10 to 20 years. Second and foremost, we have great potential to contribute substantially to Colorado's role in the energy transition that's begun in this country and in the state of Colorado. This potential, if allowed to be realized, could further secure all future remediation, reclamation, and abandonment needed many, many times over, while helping Colorado and the Denver market sequester carbon from sources that are not quickly shifted to renewable energy.
So are you talking about CO2 injection of the formation currently producing to KPK wells, the Spindle field, for enhanced oil recovery and for geologic sequestration of carbon?
Yes, that's exactly what I'm talking about. The Shannon-Sussex formations in the Spindle field are the only low-pressure conventional oil and gas reservoirs in the Front Range in the proximity of Denver's large point sources of CO2, where carbon captured from their emissions can effectively be sequestered and efficiently be sequestered on a large scale and also enhance oil production.
So after 38 years of operation, is KPK looking to sunset the company in a few years, assuming it survives this proceeding? Or is it looking at a bright future in which it is an essential partner in Colorado's energy transition?
We have a very bright future if the commission will allow it.
So why should the commission give you that chance to realize a bright future? What's going to be different moving forward, Mr. Kaufman?
I realize we have unfortunately made mistakes and not performed as well as we might have under the very difficult circumstances we have faced in recent years. And much to my regret, our relationship with the staff has deteriorated. And for that, I am truly sorry. I am the chairman and chief executive officer of KPK. The buck absolutely stops with me. As necessary in any organizational structure, tactical leadership and operational oversight is managed by professionals on our staff. But I own that we have fallen short of expectations. I own that we can do much better, and that's on me. I will have and actively foster a culture of compliance, demanding excellence, transparency, and full disclosure at all times. We are committed to improving our environmental and regulatory performance and have already begun to do so with important new hires in process and our investments in EHS personnel and capability, among other things. I hope you will give me a chance to show you what an excellent operator KP Kaufman Company can be. I promise you, you will not regret it.
Thank you, Mr. Kaufman. Just one last question. you threw out some figures about your reserves and ad valorem taxes, royalty revenues over the next 10 to 20 years. Were those figures related to KP Kaufman Exhibit 12, a redacted version of which was e-filed with our other exhibits?
Yes, that was prepared in a certified engineering evaluation from Netherlands. So,
And the unredacted version of that, just for informational purposes, has been provided to the hearings manager and to opposing counsel should the commission wish to look at the figures in that unredacted Exhibit 12. Thank you. That concludes this witness's direct testimony.
Thank you, Mr. Kaufman. At this time, Ms. Stafford has an opportunity for cross-examination.
Thank you, Chair Robbins. Thank you for being here, Mr. Kaufman. We appreciate you testifying here today. During your testimony, it appeared you might have been reading a script. Were you reading a script?
no, I was reading the questions that Mr. Jacobs had prepared in my outline of my talking points, but not a script.
Thank you. During your testimony, you mentioned a company called Kaufman Well Services. Could you explain the relationship between KP Kaufman Company and Kaufman Well Services?
Of course, KP Kaufman Company is the parent corporation. It has several wholly owned subsidiaries. Kaufman Well Service is one of them. There's Kaufman Drilling Company, Kaufman Transportation Company, Jim's Water Service, Kaufman Well Service of New Mexico. There's several entities that are wholly owned by the parent.
And what type of, or what kind of environmental consulting services does Kaufman Well Services provide?
Well, Kaufman Well Services is a full service oil and gas, oil well, drilling, completion, and facility services company. And it utilizes it has within its staff, particularly the environmental roustabout groups, it has, specific expertise in reclamation. It's obviously done it for decades. And that staff reports up through KPK to the Environmental Health and Safety Group. And, there's Max Knopp, and there's Jeff Ricard, and there's Mike Reinhardt, and, they're a group of people that manage that accordingly.
And does the Well Services Company provide any training?
Absolutely.
And who are Kaufman Well Services clients?
All of the major operators in the DJ Basin utilize us. The real estate development community uses us extensively. And they're, we've done work for municipalities and governmental agencies. We do work for the land gentry for farmers and ranchers. We'll build roads for them, put up fences, gates.
If I could back up a second, I believe you just testified that that Kaufman Well Services provides services through KP Kaufman Company. Did I understand that correctly?
Well, I mean, it is a separate legal entity, and it functions as a separate corporation. It's wholly owned by the parent company, KP Kaufman Company, and its management teams report up directly into KP Kaufman Company as it relates to environmental reclamation or engineering functions.
And so the employees you just mentioned, Max Knopp, to name one, who is he employed by?
Max Knopp is employed by KP Kaufman Company, as is Jeff Ricard, as is Mike Reinhardt.
But they consult via KP or Kaufman Well Services?
It is an arm's length transaction only in corporate structure and liability for corporate structure and liability purposes, but in its management and direction relative to environmental health and safety comes directly out of the parent company.
And I guess approximately how often is Kaufman Well Services doing work for third parties instead of at KPK's locations?
You know, it's back in the late 80s when the oil and gas price collapsed in 86, and I was a U.S. federal bankruptcy trustee. The entire vendor community in Colorado collapsed, along with the oil and gas production community. And I was forced to acquire service companies and service companies' assets and vertically integrate so that I had availability, quality control, and price control over these services. They were simply non-existent. So I ended up building a very large well service company. It was initially designed to work exclusively for KPK, but as the market particularly came back around the year 2000 and oil and gas mark to market, the price changed, we began to do work for third-party companies. And, you know, I can give you a rough estimate, and it depends at any given time. 20 to 40% of its work might be for third parties. Mostly,
I'm sorry,
service
Mr. Kaufman, to interrupt you, but I'm focused more on the past couple of years. Could you provide a percentage estimation there?
I would say it's worked 80% for KPK.
Thank you. Now, moving to a different topic of discussion, you mentioned the different economic downturns and specifically mentioned the COVID pandemic. Now, are you aware of how many of the NOAVs at issue in this particular enforcement proceeding dealt with conduct prior to March 2020?
I think most of them occurred before the pandemic.
Thank
They
you.
occurred during the crash of 2014 and subsequently, but in the pandemic, I think they had been established.
Now, excuse me. Now, you also mentioned that KPK is a cash flow business. Did I understand that correctly?
Yes, ma'am.
Do you set aside money for eventual plugging and abandonment of the company's 1,300 or so wells?
We have at times when we have a short-term schedule that we're aware of. You know, if we know something's going to happen over 6 to 12 months, you know, I revise the capital budgets of the company and the, you know, appropriation of available funds and liquidity, you know, for specific projects. I think that's the best way to answer it.
So sitting here today, could you approximate how much money you have set aside for the eventual plugging and abandonment of your assets?
At this point in time, there's limited to no working capital specifically set aside in physical form. There is working capital and liquidity that I've directed to be allocated to the projects that we see in the 6 to 12 month time frame.
Thank you. Chair Robbins, I don't believe I have any further questions.
Thank you, Ms. Stafford. Mr. Jacobs, any redirect?
Yes, just a couple of questions. COGCC requirements do not require you currently to set aside cash entirely for all of your wells in the event that you need to plug and abandon them all instantaneously, do they?
No, they don't. I mean, we have an engineered useful life of 10 to 20 years, and it'll be allocated accordingly.
Thank you. No further questions.
Commissioners, questions for Mr. Kaufman? Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Mr. Kaufman, for joining us this afternoon. Oh, this morning. I'm already in the afternoon in my mind here. Can you clarify for me that Exhibit 12 includes the reserves and revenues from KP Kaufman Company, including those services underneath KP Kaufman, so the well services, the water services, is everything included in Exhibit 12? There's just a summary, so it's hard for me to tell.
Let me answer it this way. What's depicted here are reserves and revenues broken down from oil and gas production. And then it's redacted, of course. What's not included here are the third-party service company or Kaufman Well Service Company's revenues. It also lists the capital expenditures by basin for eventual plugging and abandonment. So it shows the plugging and abandonment 20-year liability in the DJ Basin and other basins, and it shows KP Kaufman Company's oil and gas reserves.
So thank you. Could you explain to me why those subsidiaries are not included in your Exhibit 12 as part of your ability to pay? Maybe I'm misunderstanding. So if I'm misunderstanding, please correct me. Sorry.
If I could perhaps clarify, this is really just going to the reserves, royalties, taxes, wages, and the reserves are held all in KPK, the parent, correct? Because that's the exploration and production company.
Correct.
So any well service related revenue is not included here. But when we went into executive session earlier, Commissioner McGowan and Mr. Stoltz answered your questions. Those financial statements that were provided to Mr. Weiss, all of that was consolidated across all of the KPK entities, including Kaufman Well Service, trucking in New Mexico and Colorado, and the parent. So that ability to pay opinion and the information supporting it was inclusive of all consolidated financial statements. Is that your understanding, Kevin?
That's correct. Mr. Weiss's report would be the correct place to go for that information.
So Mr. Weiss's economic analysis included everything, but Exhibit 12 does not.
Yes,
Sorry, I just
because
want to make
it's
sure I'm
specific to reserves and the production lost if you were not to continue developing those reserves.
Correct.
Okay, I hope that helps.
Yeah, I think so. I would like to reserve the right to go back into executive session if I can't wrap my head around it. It's okay.
I would like to make just one statement. All of any positive cash flow generated in the subsidiary entities is allocated between maintenance of the productive asset base and well plugging and abandonment and reclamation. So effectively, since it's a consolidated financial reporting mechanism, all of the free cash flow of the corporation is cycled back to the parent and utilized to either maintain our assets or to provide for environmental reclamation or plugging and abandonment. And we can go into executive session and we can go granular on that if you'd like to.
I like to joke that my background is policy, not math. And so I appreciate your patience as I try to work through and understand those documents. I don't know if other commissioners have questions about Exhibit 12 and finances. I have other questions that I want to ask, but we good?
Why don't you just keep going, Commissioner
Okay.
McGowan?
Okay. Mr. Kaufman, I'm wondering if it ever occurred to you or your staff to reach out to COGCC staff to talk to them about, you mentioned that there were issues around COVID and staffing issues and resource issues and cash flow issues. And I'm just wondering if at any point someone said, if I gave a call to COGCC staff, maybe we could come up with a plan, because I could talk to them and let them know what kinds of issues my company's facing, and we could work together to figure out how to come into compliance or resolve some of the issues that I see are happening with COGCC.
Of course. I give very clear instructions to my executive staff that communication via email, only. From my perspective, being 65 years old, the way I would communicate historically, and I'm comfortable doing so, if I have an issue with another company or a governmental agency or regulatory agency, after the emails have gone forward, back and forth, I pick up the telephone. I go meet with them in person. When I want to solve problems between myself and other corporations, I'll go meet with the CEOs of those corporations and cut out all the layers of management. If I might for a moment, and this doesn't apply across the board, there's a culture in young people under 45 years old that are they're comfortable in text messaging and email versus physical dialogue and communication. They're most comfortable, and certainly people in their 20s and 30s. But I have drilled into my staff that if you have a problem with someone and something isn't getting resolved, allocating it to the lawyers to fight it out in letters or in lawsuits is not an efficient way to conduct corporate affairs. Go meet with them in person. Go sit down and compromise, have an open dialogue, find out what the other party wants, explain your problems. I had 3 conversations with Julie Murphy that I initiated that were very productive. I sit on the board of the American National Board of API in Washington. I had Lynn Granger, the director of API, facilitate these meetings with her. And really, the year previous to March of 2021, so I would say March of 20 through maybe February of 2021, I had 3 30-minute conversations with Julie. Now, Director Murphy. Realize, the pandemic was running at full force. People were unable or unwilling. It didn't feel safe to meet in person. It was done via Zoom calls or Microsoft Teams, whichever platform we use. And Jeffrey and I spoke to her and expressed what was happening within the company and that we would like to facilitate open conversation with the commission. And I saw this breakdown in communication. It alarmed me greatly that between the commission and KPK, very well-intentioned people, I sensed they were talking at each other, not with and to each other. And that's not how problems get resolved. And I asked for weekly or bi-weekly meetings between my upper management staff and COGC staff. And I asked to sit down with Julie, with Jeffrey and me, and perhaps Chairman Robbins or 1 or 2 others, and I'm adding this in the conversation, but to sit down with the senior management team of the COGCC at least once a month and have an open dialogue, identify the outstanding issues and try and get them resolved. And unfortunately, that none of that came to pass, which I primarily blame on the pandemic.
Thank you. If you could identify the root cause, and let's take communications out of it because I think that that's an easy thing to resolve. Looking at these NOAVs that we've been discussing over the past month, what do you think is the root cause of KPK's struggle to get into compliance?
Quite honestly, across the 7 NOAVs, the leaks themselves were very, very minor, predominantly less than a barrel. We reached containment immediately. We shut in our systems, blew down our line, shut the valves off, excavated the line, repaired the line. But as we were digging, we ran into something completely unexpected, which were large-scale historical contamination from 40 years ago from Amoco Production Company that we did not expect to encounter. And while this is not a strict liability state, and the Colorado statute provides for the operator of record at the time of the contamination that caused the contamination to be financially and legally responsible, I ordered my teams to go ahead and expand the excavations to determine certainly the lateral extent of what was going on here. Unfortunately, these 40-plus-year-old contaminated sites became the size of Olympic swimming pools or multiple Olympic swimming pools. And that's how, in 2021, we expended over $1.5 million of funds that were not our financial responsibility, and reached the extent of our financial limitation of being able to directly, manage something that wasn't our liability. And I think what happened here was, and I don't have this identified, your inspection staff are very competent professional, well-intentioned professionals and good people. But I think there was a mischaracterization and understanding of what was actually going on here at a historical contamination level, and just how significant it was. And I started to watch some of your inspectors and compliance and enforcement personnel dig their heels in and somewhat move to what was construed as an adversarial position. I watched my people get very, very defensive. And somewhere as Max Knopp has demonstrated several times, sending modified Form 27s to Chris Canfield multiple times and not getting a response is not communication. It doesn't matter if the commission was responsible need to be responsible to get back on a timely basis. What matters is that it got communicated and cleaned up. And I fault KP Kaufman Company. I think, certainly the responsibility is borne by two parties. It takes two to make a relationship. And that became for me the evidence and caused my greatest concern. The communication was just not effectively occurring at the level that it should be so that we could progress. And that's my answer.
Thank you. I don't know how carefully you looked at the NOVAVs that we've been discussing, but did you note that there were multiple corrective actions where staff said this is what needs to happen by this date, and there did not appear to be any response from your staff or any action taken by your staff?
Well, again, my responsibilities are strategic, leadership, oversight, guidance, policy, and procedures. The tactical management appropriately is done by my, senior staff. I specifically asked the environmental staff to produce for me in a weekly briefing where we were on each project, what the percentage of completion was, and what the outstanding issues were. And I think that's been the format that I would see it in has been provided to you both for the NOAVs and the 9081 order. So that's the material that was getting to me. And normally, we have weekly staff meetings of the corporate executives in the office. Those clearly stopped for a year. It all became remote. There are weekly field meetings where the members of the senior staff go to the field every Wednesday and meet for 4 or 5 hours with the leadership within KPK and Kaufman Well Service. And Max Knopp and Jeffrey Kaufman as president, will go through them at a granular detail level. I attend those meetings perhaps once every 6 weeks in the field. The staff meetings in the corporate office, weekly staff meetings, I attend every Tuesday. And I believe in management by walking around. I like to do bed check when I go in the office. And I'll walk through the hallways and talk, casually with different levels of executives and administrative staff to try and get the feeling and the pulse of what's going on. I'll walk through my oil field and walk the ground and try and talk to the crews and give them motivation see that they understand what they're doing. I'm not doing it at a direct supervisory level. I'm 10 levels removed from that. But I like to have familiarity with my people and what they're doing. And I think that's been accomplished.
Okay, thank you. Sorry. And my last question is, when you own infrastructure that's 40 years old,
Mm-hmm.
do you not anticipate that there will be corrosion, decline, unanticipated issues, and the need to set aside resources to be able to address those?
I'll answer it this way. I own the McCallum field that founded Conoco. It was discovered in 1913. It's been in continuous production since 1927. I have equipment, I have water injection pumps that are still running that were built in 1927. Now, how is that possible? There's an old saying, if you take care of equipment, it will take care of you. You have to give routine maintenance to equipment as it is operated, as it's aged, to make certain that it still has integrity. And, certainly we're very fortunate in Colorado, unlike parts of New Mexico, where we don't have a corrosive environment as to brine water, hydrogen sulfide gas. We aren't in that type of reservoir, primarily because the production here is the lower Cretaceous period, not the much older horizons that are much more corrosive with prehistoric salt water and hydrogen sulfide. And so there is very limited in our dry climate and with our low sulfur oils, relatively extremely clean oil products and natural gas streams, we don't see a lot of corrosion. But certainly there are valves and fittings and balls that seed inside gaskets and stuffing boxes where the pumping unit's polish rod goes down into the well and there's a rubber gasket there and it has to be lubricated and it has to be inspected to make sure it isn't leaking. And so we're very, very careful with our significant pumping staff they have pumper routes, they have inspection reports to figure out, to go down checklists. They have to go down those checklists and physically inspect all the pertinent items on it that could be subject to wear and tear. So there's nothing wrong with owning aging equipment. This stuff was incredibly well engineered and overbuilt. What's important though is those parts that do wear, or in the event there is some corrosion, that they're inspected and parts are changed out. And that's how they were designed.
Thank you.
Commissioner Nanjapa.
Thank you, Mr. Chair. And thank you very much, Mr. Kaufman, for coming and appearing before us and for your testimony. Sort of along these lines, upon acquiring these assets, we've asked this question of some of the other folks from KPK, but I'm curious what is your process or what is your direction that you give your staff with respect to evaluating the assets, the history, doing your due diligence? Can you kind of describe that process?
I'm glad you asked that question, and good morning. So let's say there's an acquisition of 100 wells. This is a hypothetical, but practical. And there are, 15 production facilities that those wells are connected to. The very first thing that's done, obviously, are the legal descriptions, the Oil and Gas Conservation Commission records, historical spills, complaints, violations, whatever the historical precedent has been is evaluated by both my engineering staff, my land department, law department, and and environmental department. It's a record search first. The next thing that is done is that there is a physical inspection of those assets. It's first done at a field level by our upper levels of our field operations team, Annie Silva, who you met in particular, Jeff Peterson. They'll go through the facilities. And, what are they looking for? Obviously, they're looking for signs of soil contamination. They're looking at the equipment themselves, at the separator, the treater, the tank battery, the meters. And then Jeffrey Kaufman, as president of the company, in each and every case, will walk the entire acquisition target and look carefully at it. And Jeffrey's looking for the same things, as well as casing and tubing pressure. And, does the gas meter say that it's making 125 MCF a day, which is in flow rates, and that's what they've reported. He's doing a due diligence. Jeffrey is an extremely sophisticated engineer and meticulous. He's been around the oil field since he was 3 years old, much to my wife's horror. I would have him on drilling rigs at 3 and 4 years old, walking on the floor. But Jeffrey has a love of this business, and it's extremely articulate and circumspect. The last thing we want to do is step into someone else's mess. We don't need trouble, and you don't need to acquire trouble. And so we're extremely careful and thoughtful in that process.
Thank you. And related to what you were just describing with the Conoco field, you were sort of implying a comparison that field was installed well, the equipment was well kept, et cetera, and that's why everything is working well, but perhaps not the same for the Amoco field. Is that kind of?
No, I think Amoco did a brilliant job. And if you give me just a little latitude here, what really happened here in the late 60s and early 70s, we were running out of natural gas. And Panhandle Eastern Pipeline gave over $100 million to the Amoco production company to drill the Wattenberg field into the J sand to secure supply for the state and for the country. As you remember, people were freezing to death in the 70s. They drilled J wells every 160 acres approximately. And when they went through the Shannon-Sussex formation, as they were drilling to the J sand at 10,000 feet, Amoco discovered the Shannon-Sussex formation. They were getting massive amounts of oil at 5,000 feet as they cut through the sand. They went to Panhandle. They asked Panhandle for money to develop the Shannon-Sussex. Panhandle said, no, Amoco, you can do that on your own. So Amoco drilled on quarters, in other words, 16 wells a section. They drilled nearly 1,200 wells, built the gathering system, and then they built the Spindle gas plant to process this very liquid-rich natural gas. It's 1,500 to 1,800 BTU, basically gasoline and propane. And they built that, what is now a 40 million cubic foot a day plant back in the 70s to handle and process it. I think the Spindle plant and the Amoco production facilities, both the J wells and the Codell Niobrara wells, were built at the highest engineering standards.
Okay. All right. Thank you. I appreciate that answer. So I guess the other thing that I wanted to say, I appreciated that you made the statement that the buck stops with you, and that you own that things can be done better. Given some of the discussions we've had, and the staff has proposed, compliance plans, et cetera, if we were to go in that direction, what should we do if there are additional failures?
Well, one, I commit that they'll be substantially mitigated. But, space shuttles do explode on takeoff and reentry, and ships sink. And and airplanes crash. All equipment made by man will fail.
With due
It's prone
respect,
to failure.
I don't mean to interrupt. I'm not talking about the equipment failures. I'm talking about failures of compliance, to respond to a corrective action or to provide a form or to,
Sure.
that's more what I'm talking about. So if we provide you a compliance plan
Sure.
and, have certain things that we need to bring these sites that we've already discussed back into order, what do we do if there's a failure of compliance on the part of performing an action that has been required or requested?
Okay. Well, I think the foremost way to prevent that is to have frequent, routine, direct communications between the senior management at KPK and the leadership of the commission, perhaps even Commissioner Robbins and Chairman Robbins, and for my staff to have frequent communication with your operational staff in compliance and inspection, so that if an event is going to be, a milestone is going to be missed, that communication has been communicated and that we have sought the input and guidance of the commission in how to deal with it. This should never have gotten away from either of us, and it is highly preventable. Will issues occur that will prevent a certain milestone being reached? Sure. You're going to have 4-foot snowstorms. You're going to have freeze problems. Who knows what acts of force majeure situations are going to occur? But the point is to communicate early, rapidly, and seek, if I might use the term, collegiate relationship between the commission and KPK. Look, I've had 5 directors, from Bill Smith to Brian Mackey, to Matt Lepore, to Jeff Robbins, to Julie Murphy. I've been around a long time. And the historical method of managing when there were problems, when we weren't going to meet a deadline, when there were specific issues we didn't expect to encounter, I went over to the commission, I sat down and talked to the director. And I asked for their help and I asked for their guidance. And, at the time when I started in the business, I was 29 years old. And these guys were phenomenal mentors. But, I'm 65 years old now. And I've been around a long time. And I think that there's enormous talent within the commission and within the leadership of the commission and on the board of commissioners, where without it being terribly time consuming, we have open, frequent communication so that there are no surprises to anybody. If I have a farmer that won't let me on location because he's irrigating or is hostile and is, declining egress, we've been held at gunpoint. I'm not exaggerating. We've had rifles and pistols pointed at us. That's time that you call the sheriff, and we do. But it is, problems are, obviously encountered. Most of the land gentry is tremendous, and we have excellent relationships with. My point is, by establishing communications that are frequent and repetitive, any obstacles to meeting a compliance deadline or unforeseen circumstances can be discovered and dealt with collaboratively as opposed to adversarially, or you or me getting surprised.
Commissioner Nanjapa, if I may, I want to try and further help answer your question. It seems to me you're getting at maybe a mechanism like a suspended penalty, and then if there are significant problems, a portion of a suspended penalty might be then imposed. There are mechanisms in a structured settlement that,
I'm sorry, I'd like to object to counsel testifying here. This is not appropriate.
I'm just trying to explain that.
Mr. Jacobs, why don't we do this?
Okay,
Hold it for closing. hold it for closing. You'll have your opportunity, and that is a more appropriate time. Let's finish up with the question and answer for the witness at this point.
Yes.
But we would like to hear from you on that point, and we'll do that at closing.
Very good. Thank you.
Commissioner Nanjapa, did you have further questions?
No, I did not. Thank you. That's very helpful. Appreciate the responses.
Commissioner Messner?
Thank you, Mr. Chair. Thank you, Mr. Kaufman, for being here today. I've got just a couple of questions. I think you share a similarity with me in that we like to give long answers to short questions. I'm going to ask you to be a little succinct with these answers, though.
I'm sorry.
So Commissioner Nanjapa had asked a question about some of the due diligence surrounding assets. And I think you gave a pretty comprehensive answer to the due diligence that you perform and the quality of assets that you've acquired. But I'm trying to tie together, I think, a theme of KPK seeming to blame a significant amount of problems that they're dealing with within these NOAVs to historic contamination or prior party responsibilities, or not KPK's problem because someone else did it. But if we're doing our due diligence and we have such good equipment and we appreciate the work that Chevron and Amoco has done on these particular situations, why is this? Why are we seeing these historic spills being blamed for these failure to meet the obligations of the NOAVs?
The Spindle field in the 70s produced approximately 30,000 barrels a day and nearly 1 billion cubic feet of natural gas a day. So you had tremendous volumes going through the system. In the 70s, there were spills when these facilities were brand new, apparently. There were significant spills. And for whatever reason, and the Amoco Production Company was an extremely professional organization. But for whatever reason, these spills were either intentionally or unintentionally buried and not reported. I wasn't aware of them. I didn't know they happened. And I'm sure they exist throughout the DJ Basin, not limited to KPK. You know, as you're building in, as you have failures that cause current day leaks, or as you're building in residential communities are coming into agricultural and oil and gas lands, the developers are doing environmental core samples as they build their projects out. As the midstream companies are laying a massive amount of new infrastructure, you're crossing areas that have never been historically crossed or not disturbed for 3 or 4 decades, and you're discovering these issues. You know, clearly, if we don't see anything, Commissioner Minister, if we don't see anything on the surface, and if nothing has been historically reported, and there are no records in the Cogcc, and we do a cleanup, but should be minor, and we encounter it, we transparently reported it to you in the Form 19s and in the Form 27s. We communicated in those official mechanisms. But it is what it is. You know, when I find this stuff, we want to determine the breadth and scope of it and quantify it. And I've spent over $4 million since 2018, $1.5 million in 2021. I would say I've taken enormous responsibility financially and dedicated my personnel to addressing a problem that under Colorado statute is not mine, but I've done it responsibly. And we're at a point where I need the commission's involvement. I want to be able to quickly bore in the Grant tank battery, just cores, to find the lateral extent of this historical contamination. I'm not, first let's just quantify it. Once we know it's meets and bounds, then I want to sit down with the state and say, okay, this occurred in 1977 or whenever it occurred. XYZ company major is the financial responsible party. However, I don't know if the statute of limitations is still running or not. I'm not a lawyer, I'm an engineer and an accountant. Maybe go to the state. In effect, it's an orphan well site. And perhaps a use of orphan well funds to clean up historical contamination. And perhaps the state, I'm sure Ms. Stafford has the mechanisms and the statutes and ability to go after private parties or independent parties outside of the state to recover reimbursement. But this is just the beginning. As this development continues, you don't like long answers. So I'll stop.
No, and I think you've answered the question to the extent that you answered it. I think that I've got one other question. I think you indicated in your testimony that in addition to the historic contaminations, that some of your failures to comply with the Cogcc rules and remediate the violations associated in a timely manner to difficult situations causing cash flow issues. And while I appreciate that you've committed on record to own your responsibilities and do better, what has changed from today, from yesterday to today, from a business cash flow standpoint, that will enable you to operate in a manner that protects public health, safety, welfare, the environment, and wildlife resources? Because if you couldn't do it then, I'm not sure why you feel like you can do it now.
Well, in March of 2020, oil really did reach minus $37.50 a barrel. I think averaging about $11 that month, and it ended the year about 37. Our break-even points are at $60 a barrel and better. And obviously, none of the operators in your state business models were designed to deal with $11 or $30 oil. None of them. And all of them required supplemental sources to augment that. I'm not a public company. I'm a private company. I'm the shareholder. And so I only have my own resources here. And, we survived 2016 to 21, supplementing negative cash flows with our corporate wealth and by selling undeveloped properties. We are now in a positive cash flow environment. So what has changed is as we got to May of 2021, obviously, the market repriced and marked to market again. The Saudis decided to control price instead of market share. And we're in an environment where, oil's $70 a barrel. I do expect it to be over 100 with the current international and national policies that are in place. And that will further augment KPK's cash flow as it is augmented today. We are in a positive cash flow environment, which has been disclosed to you in Mr. Weiss's report. And,
so if it did go back down to $35 or $40 a barrel, would you not be able to meet your obligations to operate in a manner that protects public health, safety, welfare, the environment, and wildlife resources.
I would be able to operate in a safe manner and protect public health and wildlife resources. But the ability to spend millions of dollars in reclamation, obviously that capital would not be readily available. So it would impair reclamation on a large scale, not the one barrel spill and clean it up. Clearly, if we encountered large scale contamination in the event that that happened, caused by us, or we encountered large scale historical contamination in a $30 market price environment, it would be very difficult for us to have the capital necessary to do that.
Thank you.
Which is why I don't intend on making any large scale spills.
Thank you.
Other questions from commissioners? Mr. Kaufman, appreciate your testimony. I'm looking back at my notes and getting back to the buck stops with me point. My notes reflect, I know we have fallen short of expectations. We can do much better we are currently actively fostering a culture of compliance. We are set to improve environmental regulatory compliance. That's kind of my notes around that statement. And is that a fair quantification of what you were trying to say there?
Yes, sir. The
Okay.
buck stops with me. I own this and take responsibility for it.
And I heard Jeffrey Kaufman similarly sort of say in my notes there, learned a lot of lessons, changed our BMTs, taking steps to ensure rules are known and what needs to be done. And he noted that a lot of this has happened following the 901A order and the NOAVs that were issued. He noted there have been a lot of meetings in the last few months of your staff important to achieve compliance with the rules. All of these efforts are toward compliance. Would you agree that this has evolved as, in response to a certain extent to the 901A order as well as the NOAVs? In other words, why we're all here today, is that fair?
We are acutely aware we have evolved in this process substantially, and we are committed to an open and transparent relationship with the commission and within the company to make sure something like this absolutely never happens again. I would like, if you'll allow me the latitude, to answer one question to Commissioner Messner, a detail I left out. Clearly, and very unfortunately, in 2016, we became naked to commodity, which means our hedges were no longer in place, locking in the forward-looking prices. So we were not protected to the downside because, frankly, in 2016, prices collapsed to $16 a barrel in February. And why would you lock that in? But moving forward, if I begin to see an instability in the marketplace, and we're at a workable price point, we will begin to use hedging derivatives to protect our downside price as necessary, preventing the negative cash flow situation that Commissioner Messner was alluding to.
Thank you for that. Any further questions, commissioners? All right, seeing none. Mr. Jacobs, any redirect as a result of questions from commissioners?
No questions on redirect for this witness, Mr. Chairman. Thank you.
Okay, then we will allow this witness to be excused at this point in time. Let's just check in with you, Mr. Jacobs, in terms of your response. Do you have other witnesses that you will be calling? You're almost out of time. Ms. Larson, do we have a time check?
Yes, thank you, Mr. Chair. KPK has 1 minute and 1 second remaining. Staff has 20 minutes and 23 seconds remaining.
Why don't we do this? It is 10 a.m. That is the time for our morning break. Let's take a 15-minute break, come back at 10:15, and then we can give you a chance to consolidate your thoughts around the use of the time and where we're at, Mr. Jacobs.
It's fine. Thank you very much.
Okay, we will return at 10:15. Speakers, thanks. Okay, we are back live. It is 10:16. I think at this point, question for Mr. Jacobs. Do you have further witness testimony for us?
No, Mr.
Maybe I'll-
Chair. I'm sorry. Go ahead, Kirk.
I was going to say, we have another witness that we're not going to call owing to the lack of time, Mr. Commissioner.
Okay. So with that being the case, then I believe the way the order is set up, we just did KPK's presentation. That included presentation on pattern of violations and inability to pay. Next would be staff responsive presentation, if any, according to the pre-hearing order. Ms. Stafford?
Thanks, Chair Robbins. We will not use our time to present or to have a responsive presentation on inability to pay.
Okay. With that being the case, then I think we are to the staff closing followed by KPK's closing. I would like to sort of bring up an issue, and maybe now is a better time to do it. And it kind of gets into, once we get through closings, then we move to deliberation, okay? As I look at deliberation, I've kind of put together kind of a script of how we will go about deliberation. And it follows, I mean, it's okay to go ahead and read this, right? So give everybody kind of a sense of where I think we need to be going. So for the attorneys and for my fellow commissioners, as I think about deliberation, I think there is a 6-step process for us. One is first to determine whether there is a pattern of violations. 2, if there's no pattern of violations, then I believe we need to go through whether there are corrective actions for the 7 NOAVs that have been reached, okay? 3, if there was a pattern of violations, then I think there needs to be 2 determinations. 1, a determination of whether to pull certificates of clearance as clearances or clearance, and then a consideration of whether to decide on no new permits, although I note that staff did not seek that remedy, okay? So then the 4th is I think we need to go through each NOAV by NOAV, and 2 considerations are there. 1, if there's a pattern of violations, whether to increase penalty for violations for individual violations, and if so, what amount. And the second piece to each NOAV is the corrective actions and whether there are corrective actions. And then that's split into 2 categories. That's the NOAVs that I did not recuse myself from, and then my fellow commissioners would go over the NOAVs in which I did recuse myself, and so I would leave the room. And then the final piece to this is consideration of ability to pay, as well as this concept of compliance plan that at least I am interested in and I asked staff to speak to, okay? So that's how I foresee our deliberations at the commission. This is somewhat of a case of first impression. We've not done this, but that's my approach to making sure that we have gone through the relevant factors that are before us I did spend time working this up with the AG Davenport, who agrees that this is takes into account all the situations. So my question at this point is I do not know that we have heard from either staff or KPK what, if any, additional action measures need to be taken relevant to the NOAVs to be a corrective action. Like, what else needs to happen for that to be considered, okay, that one's now good? Nor have I think we heard what are reasonable timeframes for those things to take place. I daylight all this because if we go down the path, and I'm not saying we will, and no decisions have been made, but if we do go down the path of some form of penalty, suspended penalty, go do the corrective actions, come back and speak to us, show that you made compliance, we need that information. We need from staff, what do you think are the corrective actions and what's a reasonable time frame? And I would like to give KPK the same opportunity. So I daylight all this not to say that I know where I'm going with this or that my fellow commissioners know where we're going with this, but in order for deliberations to be fruitful, I think that information needs to be developed. This is just one commissioner talking, but I'm just trying to move us forward so that we can be deliberative and fruitful in our deliberations. I think it might be helpful for us to take a break and allow that information to be developed, and you can interweave that information into your closing statements, which I would like to have. I throw that out there as a proposal. Suppose we do that and we take a break for a couple of hours to give both sides an opportunity to develop that information and then come back and in closing interweave this information into this deliberative process that I've set forth. Again, I'm one commissioner. I look to my fellow commissioners, good, bad, ugly, Jeff, you're off your rocker, this makes sense, etc. So I'm looking at my fellow commissioners first for thoughts about moving into fruitful next steps, and then we can then ask for thoughts from counsel for both sides. Commissioner Messner.
Thank you, Mr. Chair. I'm not going to comment on whether or not you're off your rocker, but I do think that makes sense to me to take a couple of hours. I could use a couple of hours myself to collect my thoughts, so I would concur.
Everybody else okay with this concept? I'm seeing thumbs up, nodding of heads up and down, which is a positive manner. Ms. Stafford, thoughts, ideas?
Thank you, Chair Robbins. I guess I just want to say that I believe Mr. Axelson touched on this fairly quickly in his testimony, and I believe it was in a response to Commissioner Messner's question about corrective actions timing, and I think the thought was that for the implementation of some of the things that we were suggesting related to soil impact sampling and groundwater sampling and things of that nature. I believe he landed on about 90 days would be an appropriate timeline there. We can obviously, work on that a little bit more for you, but I at least wanted to let you know that if I'm recalling correctly, Mr. Axelson did touch on this piece.
Okay, and that's fair. I think that perhaps coming back with another document so that we've got something that we can look at that's tangible would be fruitful and helpful to commissioners. Mr. Jacobs, thoughts about my concept that I've outlined?
I like it, Mr. Chairman. I do think that even Mr. Axelson noted that 90 days would require a lot of resources and be challenging in his testimony. And I'd like the opportunity of that couple hours, if we do that, to confer with my client and to explain for your benefit, for your fellow commissioners' benefit, what we think we can do in 90 days, what we think we might need more time for, whether it has to do with, larger Grant tank battery type situations, for example, to use one that's familiar. But would you entertain a document from us as well in that regard if we could put something together?
Yes, I'd like a written document from you as well.
It would be, well, I'm sorry, go ahead. Kirk, were you going to chime in?
Well, it feels, all due respect, a little bit as though the cart is before the horse, but more than that, it's a little unclear to me which corrective actions we're discussing. Are we talking about what it will take to finish the work that needs to be done under the open NOAVs? Are we talking about the proposal that was written up last night and we found this morning from Mr. Axelson?
I'm talking about the scope of work that needs to be done for the open NOAVs.
Okay.
And KPK's response could be, as to one or more of them, that it's done, that you've done what you need to be done. I'm just giving both sides an opportunity to speak to each of the NOAVs and what has been done, what needs to be done, and if there's outstanding items that needs to happen, what's a reasonable time to get that done.
Okay, that's helpful. That's helpful.
Mr. Mueller, if your client, and I asked this of both Mr. Kaufman's, desire to comment as to the compliance plan that staff has put forth, fine. I mean, that's good too. And I'm also very cognizant that I'm not putting any carts before horses. We've made no decisions. I just want all the information out there so that when we enter into deliberations, irrespective of which way we go, we're not having to come back and ask for more information.
Understood. That's helpful. And with that, I defer to and agree with Mr. Jacobs. I think a couple hours could be put to good use.
Could I ask a couple of clarifying questions?
Yes.
If we're taking these couple of hours to get this information together, I'm wondering how this information will be presented. Do you expect more testimony? Would this be just commissioner questions? I'm just wondering how this is going to go.
Yeah, and we're making this up as we go to both you guys, and so I apologize in advance. But my thought is that we would allow each side the opportunity to interweave this into a closing, and we would have questions from commissioners regarding that. I've asked all of you to have all of your witnesses available throughout this, and if a potential discussion into a corrective action gets knoppish where we need to talk to Mr. Knopp, we would bring him back. But I would want to sort of start with just the attorneys doing what they can do well, which is summarizing in their closings these additional issues that I've identified as I think would be helpful to commissioners.
Thanks, that's helpful.
Okay. And now to the time frame. The KPK has 1 minute and 1 second or something left. I'm willing to unilaterally grant additional time so that you have an appropriate amount of time to do what I've asked you to do. Mr. Jacobs, Mr. Mueller, I'm thinking you should be able to accomplish this in, say, 10 additional minutes, so 11 minutes, 1 second. Staff already has reserved time. So, I'm willing to go there, and hopefully that would afford you the and that's exclusive of questions, afford you the opportunity to sort of wrap this up on behalf of your client. Good?
That's fine with me, John.
Yes, thank you, Mr. Chair. That's very helpful and hopefully helpful to you and your fellow commissioners as well.
Okay, Ms. Stafford, if you want to lodge an objection to additional time, you can. It'll be overruled. So.
I will lodge the objection, and I understand it will be overruled.
Okay. All right. Very good. It is 10:30. I suggest, Commissioner Najapa, please.
Sorry. Thank you, Mr. Chair. Just a quick question, or just maybe another piece to add. I appreciate the plan you laid out, and I think I also concur. If possible, I would be interested in, as it relates to kind of ability to pay the costs for closing out these remaining or these existing NOAVs that are currently open, as estimated by KPK. that we could also take into consideration, if that's appropriate.
That's fine. Okay,
Chair,
go ahead, Mr. Jacobs.
we'll do our best, understanding that, to use our favorite example, Grant Tank Battery, we haven't delineated the full extent and nature of historic contamination. So we'll be, it'll be kind of a swag estimate, but we'll do our best. Okay.
Very good.
Thank you.
Okay. I've hit both parties up with a lot of requests and information. Anything further before we take our break from either side? Ms. Stafford?
No, thank you, Chair Robbins.
Mr. Jacobs?
Nothing further. Thank you, Mr. Chairman.
Okay. I suggest we come back at 1 p.m. It'll give 2.5 hours for deliberation and gathering their thoughts, and commissioners can also take that time to go over their notes. So with that, Ms. Amaro, if we could shut her down and come back at 1 p.m., and then we will start with closing statements. We've restarted the recording of the meeting, and we will allow the rest of our participants to gather with us. Caitlin Stafford needs to be brought in. Mr. Jacobs, are we waiting on Mr. Mueller, or are you on your own?
We are waiting on Mr. Mueller.
Okay.
Thank you.
There he is. Good afternoon, Mr. Mueller.
I was out in the hall. Thank you.
Okay. Ms. Stafford, are we waiting on Ms. Rosenberg, or are you doing closing? Oh, there she is. Hello. Okay. This is the Colorado Oil and Gas Conservation Commission. It is September 21st. It is the afternoon session of the docket, whose number is not right in front of me, but we all know what we're doing. So we took a 2.5 hour break to give staff and the attorneys for KPK an opportunity to gather the thoughts on closing, gave the commissioners a chance to review our notes as well. At this time, I will start as I normally do. Does staff have anything with regard to procedure before we move into closing statements?
Yes, Mr. Chair, just one brief request, if you might. As we were looking through some of the information that we were able to put together for you over the break, it occurred to me that we also might require some additional time. So in the interest of fairness, I was hoping you could grant us the same additional 10 minutes that you granted KPK before the break.
I think that's fair. So if you need your additional 10 minutes, you can have it. How much time does staff have?
20 minutes.
So you have 20 minutes and change already. I would hope that you wouldn't need 30 minutes for closing, but to be fair, we will allocate an additional 10 to you as well.
Thank you. We appreciate it.
Okay. Mr. Jacobs, anything from a procedural matter before we get started?
We're going to cover, I just want to be clear, in our 11 minutes, thank you for the extra time, our submission of a corrective actions by NOAV location and review that for the benefit of the commissioners. And then we're going to, in that same time, have about a 5-6 minute closing argument that Mr. Mueller will perform when I'm done reviewing the document addressing corrective actions by NOAV location for you. Is that consistent with your expectations?
That is consistent with my expectations. And of course, there will likely be questions from commissioners that will not count against the remaining time Mr. Mueller would have.
Okay. With that clarification, then I think we're ready. And unless, Kirk, you have an additional question.
No, I'm ready. not sure I've understood which is going to go first, the presentation of our plan or the closing argument, but either way is fine.
Whichever you two desire to figure out amongst yourselves. But at any rate, Ms. Stafford's going to go first. So
That's correct.
with that, Ms. Stafford, we will look forward to hearing closing from staff.
Thank you, Chair Robbins. If you just bear with me for a minute here. Okay. Commissioners, staff would like to thank you for your thoughtful and helpful consideration of the matters before you in this phase of the hearing, the pattern of violations hearing. First, I'm going to discuss the information that was recently requested prior to the break regarding the corrective actions for the NOA, or the open corrective actions for the NOAVs. And then secondly, I will move into staff's closing argument. So first, very briefly, I'd like to discuss staff's requested corrective actions, or I should say outstanding corrective action list for the